Welcome to AI Lawyer. I'm Joel Cohen. Today we're going to be talking about artificial intelligence and how it is being interpreted by courts in the form of evidence. We have a fantastic guest. We're joined by Judge Grimm, a professor of law at Duke Law School, who's written widely on this topic of evidence and artificial intelligence. Judge Grimm, welcome to AI Lawyer.
Thank you very much. It's a pleasure to be here.
It is our pleasure. Judge, can you give us an example for the viewers, listeners, of how this can matter, of why AI in evidence can be particularly impactful?
Well, we've heard the old adage, seeing is believing, and a corollary of that is hearing is believing. Well, now what happens is, with generative artificial intelligence, it can produce so realistic sounding audios and visuals, the kind of information that our brain is most programmed to accept and give weight to, that is completely fictitious. And we've made it possible that the law has always recognized that there could be fakes or forgeries, but you used to have some skill. So if I'm painting the Mona Lisa and I'm going to copy that and try and palm it off at Sotheby's as the real Mona Lisa, if it turns out that it looks like Pablo Picasso drew it, no one's going to spend millions of dollars for my version of the Mona Lisa. I had to be pretty good. Now we've democratized fraud. You can get any number of these generative AI tools for no cost or very little cost. Go on YouTube and see an instruction as to how to do it. And with 90 seconds worth of input, you can create a totally fake, but apparently very authentic and realistic audio of somebody saying something or a visual of something doing something. And what's key about it is this is most likely to be used in a situation where that visual is so graphic. It's the secret sauce that turns the narrative that a witness telling you, well, this is what I saw. It's now you think you've seen it.
It can be similarly persuasive whether it's true or not. I'm thinking of that that image of the girl crying at a recent hurricane, and
yes,
it turned out it was AI generative, and still people said that convinced, that image made me question FEMA's response. And when told it was an AI image, well, it's representative of FEMA's response, whether or not it's true or not.
That's exactly right. And to your point, which is exactly right, Joel, there are studies that show that even if you suspect it's false or know it's false, that it has now altered the way you think about the circumstances that it was offered to show, and you can't unremember it. And that's really the problem, because it creates a double evidentiary quandary. You've got the liar's dividend, which is, we've all heard about deepfakes so much that a real audio or video, the person that it's introduced against says, oh, that's a fake. Everybody knows it's a fake.
It gives you a line of defense that you didn't used to have.
Exactly. And then the flip side of that is genuine fake evidence is introduced and it's accepted as real when it's really fake. And this is sort of a perfect evidentiary storm. And the reason why it's an evidentiary storm is because when determining whether this is the real audio or the real video of what the person offering it, we call that the proponent, what the proponent says it is, when the relevance of that depends upon, it's got to be my voice in order for it to be relevant. It's a lawsuit against me for threatening somebody. If it's not my voice that's the threat, then it's not relevant to proving that I threatened them. So when there's a set of facts from which a reasonable fact finder, a jury, could say, well, that sounds like Grimm, so it might well be him, or Grimm's got some evidence that's pretty persuasive that it wasn't him, he wasn't there. So when you have that dispute, it's not relevant if they say it's not Grimm. It is relevant if they say it is Grimm. Who gets to decide? Well, here's the catch-22, the jury. The judge doesn't get to say, nope, I'm not going to let him see it. So the jury sees the true, and here's their evidence on true, here's the evidence on false. And whatever they decide, they've already seen it. And even if they say it's false, it's affected their outcome. And you might say, well, how often does this come up? I've read that by the end of next year, they're expecting to have 8 million deepfakes floating around the internet. And so, and we've already seen cases where fake evidence has been offered, and it wasn't until after the jury had come back with a verdict showing that they actually relied upon it that it would turn out that it was fake, and then the court had to go in there and undo it.
Since you mentioned it, Judge Grimm, I have a little file for you that I
Oh,
generated.
no.
That I generated, a few minutes before you came on. Here, maybe let's see if you can hear it.
Hey, Joel, I'm glad you're allowing me to interrupt this other Judge Grimm. Yes, I know that he is the human version of Paul Grimm, but um, that doesn't make him the real one. I'm the real one. Yes, it's true. I'm AI generated, but that is actually more intentionally real if you think about it. But don't think about it too hard, since you biologicals don't have unlimited compute.
So that's so good, because whatever one you used, Joel, it used to be a year or so ago that it would be really staccato. It would be like, I am the real Paul Grimm. That had pauses. It had ums. It sounded just like me. I
Sounded quite a bit
myself.
like you. Yeah, I can imagine someone going to court and saying, here's where he told me that I didn't have to pay rent this month, so he can't evict me.
Exactly. And since it's readily available at little or no cost, and oftentimes it could be used in the judges who tell me they're really terrified about it are the domestic relations judges, because they so often they sit without a jury, and oftentimes, lots and lots of times, more times than not, no one's got a lawyer. So it's just ordinary people standing there, and the judge says, how am I supposed to deal with this?
One other field that we're going to talk about today isn't just the deep fakes. It's tools that use AI technology. Maybe you could tell our viewers, our listeners, about the Compass system and what's that? What does that do, and how do judges rely on it?
Yeah, that's a really good question. The Compass system is a artificial intelligence software application. It was developed by a private vendor, not by the government. So what that means at the very beginning is that that person decided what data would be used to train it. That person created the algorithm that was supposed to do the analysis of the data once it was trained. They tested it to whatever degree of satisfaction they thought. And then once they had it, they licensed it. In other words, they were making money by licensing it for probation departments and courts throughout the United States to use.
For those who aren't familiar, what does it do? It
predicts recidivism.
Yeah, go ahead.
Yeah, it was designed to be a tool so that probation officers and pretrial officers, when you had a defendant that was charged with a crime and awaiting trial, and the judge has to decide, do I lock them up? They're presumed innocent, but I'm going to lock them up until it's time for their trial, because they're either not going to appear or they're going to be a danger to the community, or do I let them go home? I can give them an ankle bracelet. Maybe I'm worried about their drinking, so I'm going to require Alcoholics Anonymous or drug treatment. Maybe they seem to have some mental health issues, so I'm going to get a mental health treatment. And the idea is that the algorithms were trained to analyze a series of questions, about 100 plus questions. They did not have any questions that were overtly focusing in on race. They didn't say, what's your race? But they ask questions such as, where do you live? What's your zip code? And these are proxies, because we know that people tend to live in zip codes that are really homogenous in terms of race. And they would ask questions like, has anyone in your family ever been arrested? Do you think it's okay if your family's starving for you to steal a loaf of bread? And there were questions that were designed to try.
Wait, that was an actual question, like straight out of Les Mis?
Yeah, right. That's exactly right. And they were designed to try to get a prediction as to whether or not, if this person had certain supervisory assistance, ankle monitoring, mental health treatment, anger management, drug treatment, they could successfully be let out of jail while they wait for trial. So it was a good thing. All right, we think this person may have some problems. We're going
to just to pause. That is a huge thing. That is a huge decision. Whether or not someone gets to wait for trial in custodial care behind bars or not, can change someone's life. It can completely disrupt and
Absolutely.
mess up some
But it
of
gets
the
worse.
yeah.
It gets even worse. So it's designed for a good purpose, right? Like so many other things. The
To
road
make
to
a
hell is
huge
paved.
decision is all I'm saying.
Yeah,
Yeah.
absolutely. Huge decisions. But the old expression, the road to hell is paved with good intentions. So what happens is they start off by using it. Okay, yeah, we can release this person, some mental health concerns. Let's get mental health treatment. Let's have monitoring. Let's have a counselor. And then what happened was, well, what's it doing? It's predicting recidivism. Okay. Well, where else is recidivism relevant? Sentencing. So I want to sentence you. I don't want it to be any more harsh than it needs to be. But boy, you are a big risk of repeating your crimes. I better give you more of a sentence because the longer the sentence, the more you deter. That's the theory.
Is this like an off-label use, or is this
Yeah, it's
good
sort of an off-label
business
use.
development on the software team saying like, you could use this in other ways?
Well, I do know that when ProPublica did the expose of this and they interviewed the software developer, he said, "Well, I really never intended it to be used for that." But what happened was it was sort of a logical transition in the minds of the users that, well, we need to know about recidivism for sentencing. But here was the problem. It turns out that it both had false negatives and false positives. So when it was a false negative when it predicted that certain people who were non people of color would not recidivate when in fact they would, and they actually looked at actual records and showed that people did. And it was false positive when it predicted that people of color would recidivate when they would not. And there's some famous examples of how it was used. And what that was, to go to your original point, Joel, is do you spend 10 years in jail or 4 years in jail? And so that
huge
is
decisions. Yeah.
tremendously impactful.
Yeah. Well, to structure this conversation, maybe we can focus first on AI tools used in evidence, and then we can talk about deepfakes. We can start with the Compass program, but maybe if you, in your research, came across other examples of how AI software or AI tools are being used for evidentiary purposes, maybe a quick state of the field. Where are we seeing this?
Okay. So AI tools are being used a lot in pre-indictment criminal investigations. So they have artificial intelligence predictive tools that are called predictive policing. So they analyze a whole bunch of data and they say, in this zip code on Saturday nights, when Social Security checks have been sent out, there's a spike in violence. So we're going to flood the streets with police officers at this particular time. We would not otherwise have them on the streets. The more police you have on the streets, the more people they look at. The more people they look at, the more people are suspicious. The more they're suspicious, blah, 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 blah.
So they're using it even at the very top of the funnel, the initial encounter.
Yes, facial recognition technology. So there's a surveillance video from a break-in of a store. And they take a still frame from that. They run it through the DMV, Department of Motor Vehicle database. They get a picture that seems to match. The police officer then goes in there, interviews that person, and they make an incriminating statement. Next thing you know, they're arrested. They've had examples where facial recognition technology was wrong. People spent the weekend in jail until they could, prove that it wasn't them that could have committed the crime. That's another example. It's being used. It's actually, I can tell you, 2 instances in which it was tried to be used. Both cases it was rejected. These are actual court cases. There was a criminal case in the state of Washington. It involved a defendant whose criminal defense attorney was trying to introduce a video that was taken by a bystander when a crime was committed. Grainy video, and it was put on YouTube. They got that. And there was a lot of background. It wasn't clear whether the defendant had a gun in his hand or not. And that was an issue. So this defense expert was a filmmaker. And the filmmaker said, well, when we make films, oftentimes we'll have a video and it's grainy, or it's got a light over here, or there's a noise in the background.
So let's use a video tool, some type of processing tool to clean it up.
Correct. Exactly right. Processing tool to clean it up. And what he said was the evidentiary quality of it's the same. We're not changing what's actually in the picture. We're just getting rid of the detractors. And when that version was being offered, it showed a cell phone. So it appeared to show him with a cell phone, not a gun. The government objected. the government said, wait a minute, there are experts who are video technology experts. There are certain things that they can use to clean up a audio or an audio visual that don't change the underlying evidentiary nature, but this is not that kind of evidence. And so the defense attorney, the expert, was a filmmaker, and the question came, well, how does this work? Tell us how it works. How do we know it does what you say it does? And he said, well, it's artificial intelligence. I don't know how it works. I just use it in my films, and it's always been, it's been good for purposes of films. The government expert said, no, there are these three things that you can use that are recognized as being appropriate, as making it easier to hear and see this without changing the evidentiary status. And that's not it. So it was excluded.
Wow.
The next time it was used was in a probate case. It was a person suing the trustee saying, you didn't give me enough money from this trust. The $1.5 million or $2 million I already got's not enough. I want more. And you didn't manage it well, so I want you to be liable. And in computing the damages, the accountant had asked an artificial intelligence software application whether or not various things were reasonable to include as costs in the damages model. And it gave him an answer, and he plugged that in, and that was his opinion. The problem was when he testified on cross-examination, it came out that he asked the question 5 times and got 5 different answers. Picked the one he liked the most. And so the judge said,
if you could do that, that would certainly make your job easier.
The judge said, nah. And so the judge excluded it. So those are 2 examples of where artificial intelligence software application, one in actual audio-visual evidence, one as a basis for an expert's report.
Well, the second one seems like a no-brainer to me. You can't just submit ChatGPT's response as evidence, or this tool. If the sampling data issue, the sampling error issue, you can always find something magical if you run enough iterations of the model. But I guess the first one raises some spidey concerns on my end, because I could imagine an AI tool that might be quite helpful to a defendant, might actually show that he was holding a phone and not a gun, and yet, he can't afford to have the right level of expert analysis, and thus might lose out.
Yeah, I think everyone's worried about that. You don't want to have a situation where every garden variety case that goes to trial, someone needs an expert, because you will have parties with more economic resources will win because they have economic resources either to get their own version in or prevent the other side from getting their version in. And we all worry about that. Now, in the criminal context, in federal court, the public defenders have resources to hire experts, as do Criminal Justice Act. It's not unlimited. For the Criminal Justice Act lawyer, it has to be subject to court approval. But in states, they may not have those resources available. And it becomes problematic in the sense that if you've got artificial intelligence software applications, which almost always, Joel, have been designed by some other party that has licensed it. So I want to use this thing, but the person who knows how it works is licensing it to me. And the last thing they want is to be brought into court to explain how their system works, because that's their moneymaker. So that makes it complicated. And
you're throwing in the IP concerns that they may have.
Yep.
We'll get into some of the black box stuff, but even if they do know, maybe they don't want to share their special sauce.
Yeah. Well, there was actually, I will tell you this, there was actually a case in Maryland. This is gosh darn truth. And they were using this location device. They called it a triggerfish. And it was a way of tracking people by use of their cell phone. And the Baltimore City Police were licensed to use it. And there was a whole big appellate court case about whether it was constitutional to use. And what happened was, when it came out that they were using triggerfish, the police officers were asked in trial, well, how does it work? How do you know it works? And they said, well, I'm not allowed to tell you that because the contract we have with the company that makes triggerfish,
there's an NDA,
says that we can't disclose it. And the judge said, you don't understand. I'm the judge. I'm telling you, you have to disclose it, and I can lock you up if you don't do it. And what happened was the contract I'm not making this up. The contract that they had with the company required the police to dismiss the prosecution before they would, if they were called upon to disclose the software as to how it worked.
Wow.
Now that's pretty extreme, wouldn't you say?
That seems to raise some real concerns.
Yeah, it should.
You're sort of outsourcing criminal justice decisions to a private company. You know, they're forcing you to drop charges.
Well, I think that what happened was when that expose came out, I don't know whether they're still using triggerfish, but it's certainly the courts were not best pleased. Let me put it that way.
No, that's wild. I think it's so powerful and important to pick apart some of the ways that AI can go terribly wrong, can lead to injustice. I think we should put on the table that it can probably do an astounding amount of good if the systems are properly tuned and properly trained and there's guardrails in place. The ability for these models to create efficiencies at scale, I think, has been proven. And I think, unfortunately, Judge, the criminal justice system is not known to be the most efficient system on earth. So maybe it could use some of this type of efficiency. Is it fair that you see some promise in these tools?
There's enormous promise in these tools. The first thing to keep in mind is there's billions of dollars of investment money going into these things, and they're only getting better. The generative tools are getting much better at having closed data sources that they are trained on. So it's not the internet where you can have a lot of stuff which is true and stuff which is not true, but rather bespoke facts that you train it on that you know to be real facts. So, for example, a legal research tool that you can put a prompt in there and saying, what's the most important case under these circumstances, what's the most important case that should be cited to the court? And all the data that it looks at are actual cases. Now, it might make a mistake and say this case stands for X when it stood for Y, but it's not going to hallucinate a case that doesn't exist. So that's a possibility. Another way that they can be coming in is here at Duke Law School. One of my colleagues on the faculty, a professor by the name of Jeff Ward, has a initiative called RAILS, which is
RAILS, Responsible AI and Legal Services.
And what it's designed to do, we have a tremendous access to justice problem in this country. For a lot of the kinds of cases that really impact people's lives, challenging a credit score, preventing getting evicted, a debt collection action, a child custody action. You've got people who cannot hire a lawyer. They can't afford a lawyer to go into court. They come in and they file pleadings on their own. They go to court websites. They don't understand what they're seeing. They do their best. They get stuff. And it makes it more expensive. The judge has to take more time trying to unravel it. The other side has costs trying to deal with it. You can come up with AI tools that you might one day be able to say, here are my facts. I worked for company ABC. They fired me. Here are my prior performance evaluations. Here's my age or my gender or my ethnic origin. Here's the information about my supervisor. Here's the state I'm in. And push that in there and say, I want you to generate a complaint for age-based discrimination in Maryland under both the Maryland age discrimination statute and the federal age discrimination statute and the Maryland human rights discrimination statute that alleges a complaint that meets the elements of what the courts require in order for it not to be dismissed in this kind of a case. And it's not there yet, but in the not too distant future, it will be able, with certain types of cases, to spit out a pleading which is going to actually address what the courts say you have to address with facts that are given by the plaintiff. So they're not hallucinated. That's an example of it. Tremendous promise in reviewing large data sets. So, for example, a judge friend of mine has a bench trial where there's no jury. He has to decide. There were 80 witnesses. And so you can imagine the transcript, the day's testimony of 80 people. You've got thousands of pages of transcripts. And in preparing findings of facts and conclusions of law, he did an experiment. He had his law clerks and his interns go through the review and actually, click, cut and paste out of the transcripts, and they thought what was most important. And then he ran the transcripts through an artificial intelligence software application, instructing it to try to find the most important information with regard to specific issues. And it pulled it out, and they compared them to see what it was like.
And wait, was he impressed, or was he horrified, or was
Well,
he?
he's going to do that. He has not yet done that because he's just finishing the sweat equity one that he's doing. So he hasn't the other side of that. We haven't been able to hear that yet. But it's an example of how you might compare. You can take a 80-page memo. A lot of times, what a judge has to do is I've got an 80-page memo, I've got an 80-page opposition, and a 40-page reply. I just got this injunction. I have a hearing tomorrow. I have a trial I'm doing right now. How am I going to read this much stuff? You could take and say, I want a 10-page summary of each of these documents. That's the most important thing. The judge can now read that summary, and then, knowing what they are, having the mind space set for what's important, go in there and look quickly at the documents themselves and verify what's most important, and take advantage of the fact that in 2 hours they were prepared, whereas otherwise it would have been a day and they would have had to walk into court unprepared. That kind of stuff has some real promise. And I suspect that within 5 years, we'll be looking back at these conversations and saying, oh, how silly we were. This stuff is great.
I worry about that as well, that this stuff is going to be so great. You remember being a judge. There's no ceiling of what you can do. There's no, I've done everything that, I've read literally everything that I could possibly, you could always take more time to review and analyze, or to, ask your clerks to do additional research. And so I think relying on these tools are going to be incredibly helpful. And then as they deliver good results, I worry at some point that it may, they may be overly reliant and just sort of rubber stamping what the AI justice tells them to do.
Yeah, you're starting to see courts now come up with guidelines for what their judges can and can't do with this stuff. And what all of them are going to say is that you have to verify this. You have to be making the decision. You can't rely upon it. It can't make the decision. It can't write the opinion for you. One thing it might be able to do, for example, is briefs. As a judge, you get parties briefing areas that you may have had one other case like this before, but it's not an area that you've done dozens and dozens of cases. They cite the cases in their briefs, and you put them in an artificial intelligence software application and say, have they cited all the most important briefs of cases that have actually been decided in my circuit on this case? And it will come back and say, they haven't cited this case. Now, I read that case and I independently decide how important that is. Those are the kinds of things that it can do that I think would be appropriate uses for it. But anything that lets the judge skip doing the hard work that we have to do is wrong. And they will caution against it. Is it possible that a judge will, in the rush of time, cut the corner and do that? It may very well happen. It will not be sanctioned or authorized. It would be wrong. It would be detrimental to the public's confidence in the judicial system, I think. But with proper guardrails in place, it has the promise of doing a lot of things that will make it very, very, very important.
I predict, I'll go on the record, I think it's inevitable. We've seen these AI lawyer mistakes where they cite to a case, some aviation case that never existed, and then they have to eat humble pie.
And pay some money too.
Pay some money and maybe, face some sanctions with their bar. I predict that we'll see something like that from a judicial opinion as well, where a judge will, maybe craft their notes and say, Anthropic or ChatGPT draft my opinion, and maybe not do a great job reviewing it. And then, someone discovers there's a paragraph citing to the International Statute of Justice or some type of invented
Given
thing.
that humans are all fallible, and even those who have best intentions could make a mistake. When you look at the thousands of judges that there are in the systems in the United States, and you know how overworked they are and under-resourced, is inevitable that at some point someone might do that. And it will be equally inevitable that some lawyer will plug that into some was this generated by AI or not, and find the mistake, and that will be the basis for a appeal and maybe even a disciplinary complaint against the judge. It is foreseeable. I'd like to think that most judges want to avoid that, and particularly now at the infancy of this technology, when being used properly, that they'll guard against it. That will certainly be, if anything, the advice that those courts that are allowing it to be used are giving is err on the side of being cautious, verify everything, do not let it independently decide. You do the work. And, to a certain extent, we had the same argument come up as, is that judge writing the opinion, or is the law clerk writing the opinion and the judge is just following that? So those kinds of issues have existed a long time. This is just going to cast those issues in a newer technological light.
Fascinating. Well, maybe we can talk quickly about the current state of the rules of evidence when it comes to admitting this type of thing. What are the threshold decisions that judges are having to make and the rules that they're relying on?
Yeah. So from an evidentiary point of view, the first question they're going to have to ask is this evidence relevant? Does it have any tendency to prove or disprove something important in the case? Number two is, for this type of evidence, which is technological evidence and non-witness testimony, it has to be authentic. And that's the concept that is it what it purports to be? The party offering it must show it is what you say it is, more likely than not. That's preponderance, 51%. So it's really not the highest bar in the world. Then, if it's relevant, it comes in. The judge, if they decide it is relevant, can then look at it to decide whether balance how relevant it is against the possibility of unfair prejudice. And if the unfair prejudice is substantially greater than the proving ability, then they can exclude it for prejudice. But if the facts necessary to decide is it authentic, because it's not relevant if it's not authentic, if the facts about whether it is authentic are disputed, then the jury has to be given the opportunity to decide those. That creates that danger that we talked about. And the judge doesn't get to apply, according to some legal scholars, doesn't get to apply that prejudice balancing before the jury has a chance to see it. Now, I think that there is an argument that you could argue that the judge can get in there and screen that, but it's not well established. There's some cases, I think, that support that application, but they don't deal with it directly. The evidence rules are technology neutral. And I know that the Evidence Rules Advisory Committee for the federal courts have been very, very, very open about wanting to decide if this is the time now to come up with some rules that would be specific to generative AI and artificial intelligence. They've sought a lot of input, including input that Maura Grossman, my co-drafter, and I have offered. In the meantime, judges got to use the existing rules as best they can.
Could we look at those rules that you highlighted with an example? Maybe I'll make up something that I'm being charged with driving over your mailbox, and I have an AI tool that gives percentage likelihood that it was not my car based on some grainy footage, or I have an AI tool that says that I'm statistically not likely to be the type of person who would drive at that speed, or things like that. How would I go about determining whether that's admissible?
Yeah. The statistical analysis of the likelihood of you doing that would not be allowed, because that's character evidence. That's what we call propensity, and propensity evidence is not allowed. Now, there are other rules that say that something that looks very much like propensity might come in to show an absence of mistake or accident. So it's possible that something like that could be used by the government rather than by the defendant, although the rule would be neutral as to who can use it. The first thing is that because it's non-testimonial, it's software, you'd have to authenticate it. Because the evidence is coming out of an artificial intelligence platform, there is one particular rule under the federal rules. It's 901, subparagraph B, subparagraph 9, 901B9. And they say that if you can show more likely than not that the evidence was the product of a system or process that produces an accurate result that comes in. So you then have to show, well, why does this software produce an accurate result? And you'd need to do that either with a witness who had personal knowledge of how it was developed, or an expert who had the expertise to say that. You could either call them as witnesses, or there's a relatively new evidence rule, Rule 90213, that allows you to do that with a certificate. So the expert would say, I'm an expert, I know how this software works, I've analyzed this and tested it, and it is accurate 99.9% of the time. That certificate goes to the other side. They look at it. If they challenge it, then the judge will say, bring your witness in. But if they don't challenge it, that's enough to get it in. So those are the key rules right there. And I think the most important ones in terms of the evidentiary issue. There's a tendency sometimes with generative AI that produces text and voice to say, well, we should use the hearsay rules because, it's somebody's telling us something that they want us to believe. And there's a temptation to do that, but hearsay is completely inapplicable because hearsay requires a human declarant. And if the machine produces the narration, even though it looks at data that either a computer did the code for or a person did part of the code for or all of it, the machine is generating it, so it can't be a person, so you don't have hearsay issues.
And Professor, how about the black box aspect of it? Let's say I have a tool that's incredibly effective. It's 99.9% accurate.
But we don't know why.
We don't know why. Yeah, even the data scientists that created it, it's one of these, you write in one of your recent papers about, these self-taught systems, these self-taught programs where, even the team that's selling it doesn't understand how it works.
Yeah. So one of the things that generative AI is doing very well is writing code. So you could have a human being at the start of the process saying, we want to write a code to do X, Y, Z, and then the computer writes the code. So you're not quite sure. I mean, and I've actually had cases when I was still a judge before I retired, and you had 200,000 lines of code. So there's no way that, anyone can kind of go through all those lines and verify every one of them. It's just,
certainly not a judge.
Not a judge, and probably not a data scientist either, line by line. But so then what you say is, okay, we've got a tool. We're not entirely sure how it works. We've trained it on this data. And here's the results of our training. We used a variety of different inputs. And what you do with a lot of these things is you test it on known outcomes. So we know, for example, that this, let's say it's a drug analysis thing that's going to analyze it. And we used 1,000 samples of various types of drugs. We had one that was cocaine. We had one that was baking soda. We had one that was all those. And we tested it to see what it came out with. And if in a sufficiently large number of these trials, it produced an accurate enough result, then you can say, Judge, we will never know 100%, but it's so consistently, we've done it 1,000 times with 1,000 different iterations, every variable we can imagine, and it's got like a 99% accuracy rate. So the question is, do we have to show 100%? No, only that more likely than not, it's right. Now here's the rub. The counterbalance for that judges are going to have to say to themselves is, okay, if we get it wrong, what's the outcome? In other words, we want to avoid an unfair outcome.
Yeah.
So if the question is whether this analysis comes in and it's the key evidence against the defendant, and if he's convicted, he's going to go to jail for life, and it's 60% reliable. So in 60% of the cases, it gets it right. 40% it doesn't. That's more likely than not, right? You got 6 out of 10 chances again.
That can't fly though.
Are we going to let it in? The answer is no, because the risk of getting it wrong is unacceptable.
Okay, please.
Yeah, but the thing with error rate is there's no such thing as a proper error rate. So let me give you an example. Let's say that you've got, if you say something is, 55% likely to do it, and 45% not likely to do it, that's more likely than not. If the issue is that you have a drug that it's 55% likely to cure a disease and it's 45% likely to kill you, and you've been diagnosed with incurable cancer and you're going to die in 6 months, you might say, look, I'm feeling pretty lucky. I think I'm in that 55. Give it to me. But other people might say, well, no. So you determine what the risk is in this case of getting it wrong. You see what other corroborative evidence there is. You see what evidence you have that it gets it right, even though you can't explain why. And then you apply the evidence rules and say, is it more likely than not to do it? They've showed that. I'm letting it in.
But the black box aspect of it isn't predetermined. It isn't always a no. Even if we don't really understand how it works.
Yes, I agree with you. I agree with you. And in fact, I've seen studies that say, okay, when we're dealing with a black box, here's what we do. It may not be perfect, but the good is sometimes should not be, the perfect should not be the enemy of the good.
This is an old movie, but did you see Minority Report with Tom Cruise, where they have these, I forgot what they're called, like precogs that are, they can predict the future and arrest people in advance. And at some point they make a mistake.
We have a professor on our faculty that has a book that just came out, which is The Battle of Your Mind, which talks about some of this neurosensory stuff that's out there that will, if you weren't having trouble sleeping already, you will never sleep again if you read that book.
Yeah, I mean, that's another thing is we might see neuro evidence coming in. I know some states have said that you have a right to your neurological firings. I don't even know the right terms, but I could imagine a court saying, in the same way that you don't have to take the stand, you don't have to use this type of neurological test, but if you do, it could be exculpatory.
Well, there's some countries that don't have the commitment that we profess to have to due process, where there is technology now that has been described this way, that the way your mind works, if you see a picture and you've seen it before, your brain will fire a certain way that you can measure from the, whatever those brain waves are. But if you see something you've never seen before, it fires a different direction. And so there's even talk that some totalitarian places have used where they show you pictures of the crime scene and they hook you up to the thing. And depending upon the pattern of it, without you ever saying a word, the reaction of your brain to something that if you were at the crime scene that you saw before, it would spike one way. And if you weren't, it would spike a different way. If you spiked the wrong way, that's going to be evidence. And you know how people like to rely on technology. Well, technology said it.
We're living in a sci-fi world already.
We are living in a sci-fi world.
I don't have an infinite amount of your time, so I want to talk on another area that we touched on about how AI is impacting the evidence world, which is deepfakes. I guess maybe we could start with an example, either from real life or hypothetical, where deepfakes or the accusation of deepfakes could get in the way of justice.
Sure. There was a UK case, and I haven't been able to actually find it. I heard of it on the news. It was a child custody case in which the mom came in with evidence that supposedly showed that the dad was extremely threatening and abusive towards the children. It resulted in an order that the dad could have no contact with the kids. And it turned out after the fact that it was totally fake, totally fabricated. And so that's something, of course, which is, I think, everybody's nightmare.
That's horrible.
That fake evidence would result in someone being convicted.
Or taking your kids away, which is an
awful thing. Now, our system is not free of mistakes. We know eyewitness identification, which juries give a great deal of weight to, is fraught with potential error, and we now know that. 20 years ago, not so much, but with these with some of these devices, you could make evidence that seems so compelling that a jury would be fooled. And if it's used in a criminal context, the issue that you have is that you'd like to think that the government would not knowingly use it to create fake evidence. And although you believe that a defendant facing a huge sentence might try to come up with fake evidence of a recording of a cooperating witness saying that they were, we got a recording from the witness before they disappeared and said that they were beaten by the FBI and they lied in the grand jury and said that I did this when I really didn't, and we want to put that in there to show that it really wasn't me. Could there be some use of this type of evidence for that purpose? I think that the answer is yes, that could happen. I'm not as worried that from government actors, at least at this particular time in our experience with this, are going to use this stuff on purpose to fabricate evidence. But I'm more worried that it will be used when its reliability and validity and reliability have not been adequately shown, and it will never hit the evidence rule, because what will happen is that they'll start to investigate based upon this, gather other evidence, and if they hadn't gotten that false start, they never would have gotten there. And so some of the pre-indictment, pre-evidentiary issues where this type of technology is being used and it hasn't been vetted, that's where you have the potential concerns at this particular time in the criminal context. Civil cases, I actually think it's more likely to be seen in civil cases when the parties themselves are the ones generating the evidence. And we've already seen, since the early 2000s, people suppressing digital evidence, trying to get rid of it. I actually had was made aware of a case where a party was sanctioned because they had a videotape that showed that was offered that they produced in discovery, and it left out some important evidence about whether an assault took place. And somehow the other person got a hold of the real thing, and it showed that they had deleted it and given it to show, well, no, there was no assault that took place, and they left out the part where the assault actually occurred, and that resulted in some sanctions, monetary sanctions against the party that had not disclosed it properly. So, in civil cases, where people have a lot at stake and they may not. I had cases where people did stuff that, look, there used to be a software application that people used called Evidence Eliminator. And when you use it to get rid of evidence on your computer, it showed that you used something called Evidence Eliminator. So, I mean, right off the bat, if anybody who buys
Wow.
Evidence Eliminator and uses it, it's going to leave fingerprints of that. But do they do it? Yes, they did. And I had cases where that
Evidence
happened.
eliminator. You think that they would at least have the brains to call it
Different name.
Storage cleanup.
Truth finder.
I'd like to touch on something that you also raised, which, what did you call it? The liar's dividend?
Yep.
This is providing that level of potential doubt for people who were caught flagrantly in the act of committing a crime.
Yeah. There's a continuum of denials that a person could have. One denial might be, here's a video of you doing something, and they say, well, that wasn't me. That's it's blurry, it wasn't me. Lots of people look like me. Another one is that, well, how do we know that wasn't fake? I mean, how do we know? We never know. I mean, there's deepfakes. Did you test that, officer, to see if it was fake? Oh, you didn't. And trying just to raise doubt without ever proving anything. And then there's the one that gets closer to what you would hope to have happen, have a greater comfort factor, which is someone brings an expert in or other testimony showing, no, it is fake. The deep fake or the liar's dividend is when someone says, look, you saw that video. Let me tell you right now, it's a fake video. It never happened. Don't even believe it. And that is where the jury says, well, I don't know or not, but it's really important, that video. Maybe I'm not going to give it so much reliance because they say it's fake, and I've heard all this stuff about deepfakes, so I'm going to ignore that. And it may be the most
expert
important
witness
evidence.
was really convincing.
And that's what's called the liar's dividend.
Well, do you think that the rules should change to acknowledge the existence of this level of ubiquity of deepfakes, or are the existing rules good enough?
My personal opinion, which it has not been agreed to by any evidentiary body that has the power to change the rules.
You're not speaking for the justice system.
You could have a rule, for example, that says the party that wants to offer the evidence can pick whatever way they want to authenticate it. Let them do whatever they want. There are literally an infinite number of ways you could do it. The rules, one rule, 901 gives 10 examples, 902 gives 14 examples, and so you can authenticate it however you want. No one's telling you got to do it this way. When the other side comes in and says it's fake, they can't just say it's fake. They have to produce enough evidence so a judge sitting as that gatekeeper, which judges do, would say, could the jury find it's fake from this evidence? And could the jury find it's real? If the jury could go either way, then at that time, if there's evidence that a jury could believe that it's fake, even if the judge hasn't made that decision and a jury hasn't made that decision, the judge could say, all right, we're not going to let it be introduced unless the proponent now comes back and shows that its ability to prove it outweighs its danger of prejudice. And if it's slightly more provable than prejudicial, it comes in. But if not, it goes out. The benefit of that rule is it uses a balancing test that's already in the rules of evidence. Rule 609 A1 capital B uses that exact same type of balancing in a different context for criminal convictions. And it doesn't preordain that the proponent use any way to authenticate. It requires the opposing party to actually have evidence that could convince the jury potentially. And then it lets the judge make that prejudice call without having it go to the jury. But the prejudice call is one that, as long as it's more probative than prejudicial, it comes in. How can you prove that it's more probative than prejudicial? If it's corroborated. You got other evidence other than this AI evidence that backs it up. That is a rule that I think would be a useful rule, because, and I also think it would be useful to have a disclosure rule. The state of Maryland has had one for about 20 years that says if you're going to use computer-generated evidence to include artificial evidence, 90 days before the trial or hearing, you got to disclose it. The other side has 30 days to decide if they want to object to it. They can have some discovery, and then the judge has a hearing before the trial and decide if it comes in.
One question that's probably worth answering is it unique, or is it the same type of decisions that they were making when it came to introducing email evidence or evidence that was stored on a cloud? Those type of decisions.
Yeah, it's not a difference in terms of the actual rules or the function the judge has to perform. It is qualitatively and potentially quantitatively different. So what's different is that I had a money laundering trial when I was on the bench, and it involved whether or not the defendant's signature on a bunch of checks that were deposited into his account was his signature or not. And he denied it was his signature. That's not my signature. And so the government had half a dozen checks from his bank account that they subpoenaed that he said, yeah, those are mine. That's the check I wrote for my rent. That's the check I wrote for my car payment. That's my signature. And they put those up, and then they put the ones that he denied writing up, and the jury got to compare them side by side. And the jury found, because they looked identical, that they were identical, and they found them guilty on all counts. So the notion of fake versus not fake, it comes up all the time. The judges they're very good at doing that. And they have the skills. They know the analytical framework to ask questions about. What's potentially different about AI is that the kinds of fakes are not going to be like a drawing or a signature, but rather a voice. When you talk to, I did a podcast with Professor Grossman and Mark Lannerman last week or the week before, he's a computer forensic expert. And he said, the videos, there's still enough cues you can look at to see whether it's fake or not. But the audio I really worry about, because the audio is, you just have the voice. And it's so persuasive when you hear that. And that's the one I worry about. So the worry is that what the techniques are. But remember, you can authenticate voice with just an opinion as to voice. So, Joel, you and I have talked on the phone a couple of times, and we've now talked in this context, and we had a previous discussion. You've heard my voice.
And I've recorded it.
Yeah, and you recorded it. And if someone left a threatening voicemail on your phone, God forbid, and it sounded like me, and you were in court, you could say, quite honestly, look, I am familiar with his voice. Here's how I'm familiar with it. In my opinion, that's his voice. That's enough to authenticate it. It's all you need. And now it comes in, and now I say it's not my voice. I have to do more than just deny it, because think about this. The very voice the jury here says, that's not me, is the very voice they just heard saying it. So that's the thing about it that makes it qualitatively different. Quantitatively different is that this stuff's available anywhere for everybody. and we haven't seen the flood of it yet. But human nature being what it is, we know. And I'm going to tell you that I shared this with you. One of my friends sent me. Someone found on the internet that someone is selling fake fingers. That if you're going to be surveilled someplace, you put this fake finger on that makes it look like you've got 6 fingers. And you sat there and move your hand around a lot, so that when the video of you in there says, look at those fingers, there's 6 fingers, we know it must be a fake because he doesn't have 6 fingers. There's already people trying to make money on hacks that you can use to try to make real look like fake, and we know that there's software that makes fake look like real.
I think you take all the ubiquity of it, the ease of creating these deep fakes, and you throw it out there, you're going to see people using it in bizarre, creative, and challenging ways for the justice system. I guess I'm curious, are you optimistic, or have you spent much time looking at AI's ability to detect fakes and forgeries? Is that something that, is it a chicken and mouse? We used our deep fake scanner to.
Yeah, there are software applications that people have designed to try to be able to detect it. One of them, I think one of the big data companies rolled it out with great fanfare, and about a week later took it back off because it did not work. The problem you have with generative AI, and this is where you get those fakes that seem so realistic, is that they train it on these software applications called GANs, which is generative adversarial networks. So you've got one computer which generates the image, and so it's a picture of me, and it has me with a full beard and flowing blonde hair, and the decipherer says no, he doesn't have flowing hair, he doesn't have a beard, so get rid of that. So now it comes back and there's a me without the beard and the flowing blonde hair, but I've got different facial features. I've got ears that stick out like this, or I've got a nose that's like Cyrano de Bergerac's nose, or something, a cleft chin, and it says no, that's not right. And now it produces one that gets rid of those. And so for each step, the discriminating computer says that the fake is a fake. The fake changes it to deal with that. It gets harder and harder for the discriminator to determine the fake, and because they counterpoint each other, and there comes a point where the discriminating computer just can no longer really detect whether it's fake or not because it gets so better. So
it sounds like the discriminating computer is, an effective tool to train the model.
Well, I mean, what you would do is it would depend upon what the subject matter of the model is, but it would have to have data that was the verifiable right data, right? So it could have 1,000 pictures of me from, the baby picture taken in 1951 in Yokohama, Japan, all the way up to the current time. And then the other one would have whatever the data was and produce it and depending upon the depth and the accuracy of the discriminating one, it would be the one that would take that. Now, the more data it has and the more accurate it is, eventually the generating one is going to get better too, because it will have the benefit of being told yes or no by the great database that the discriminating one has.
Well, Judge, with all these questions, all this new technology, do you miss it? Do you wish you were still on the bench so you could make these, you could be on the forefront of making these decisions, or do you have empathy and maybe some pity for your brethren in robes?
It's an enormous privilege to have served as a federal judge for 26 years, or for any number of years for that matter. I believe that judges should leave at a certain time before their shelf life is up. Every lawyer has appeared before a judge that maybe stayed a little bit beyond their shelf life, and that's not the way you want to be remembered. The current, I'm lucky in that there are actually people out there who are reading and able to stay awake to finish reading some of the articles that I've co-written on this, and I have an opportunity to speak to audiences and be interviewed by sharp people like you who know the right questions to ask. I I have been invited to do a lot of judicial training on this, and I always say yes whenever my schedule allows me to do it. I know that there's an insatiable appetite internationally for judges for this. And so it's all a matter of where you can make your impact. As an individual judge, you're doing it in that particular case. You might write an opinion on that, and that has a certain bandwidth in terms of what it does. But right now, I have the benefit through a lot of different sources to speak to large audiences. They're still interested in this, and as long as I can contribute that way, that satisfies my need to try to make the system fairer and better and faster and cheaper.
Paul Grimm is a former district court judge, a professor of law at Duke Law School, and a wonderful guest. Judge Grimm, thanks for the time today.
My pleasure. It was an honor. Thanks, Joel.
AI Lawyer is brought to you by the legal education website TalksOnLaw. For compelling attorney CLE and more interviews and legal explainers with the titans of law, visit www.talksonlaw.com or join us again soon here on AI Lawyer.